Start. This case has been referred to this bench for a decision of the question whether in a letter's patent appeal the time requisite for obtaining copies of the judgment and decree should be excluded in computing the period of limitation fixed by the rules of this court for preferring a letter's patent appeal. A full bench of 4 judges of the Allahabad High Court in Fazl Muhammad versus Full Kuwar has to be considered, and if found to lay down incorrect law has to be overruled. We think in these circumstances it would be advisable that a bench of 5 judges be constituted in order to decide the case. We therefore direct that the papers of this case be laid before the Honorable the Chief Justice for Constitution, a larger bench. The question which has been referred to this bench is whether the time required for obtaining copies of the judgment and decree appealed from should be excluded in computing the period of limitation for preferring an appeal fixed by the rules of this court under the letter's patent. The relevant facts are that judgment in 2 connected second appeals was delivered by Brij Mohan Lal, judge on 3rd October 1957, the learned judge granting leave to the present appellants to file a further appeal under the letter's patent. The letter's patent ceased to have effect from the date upon which the UP High Court's within bracket amalgamation order 1948 came into force, but by virtue of clause 9 of that order and article 225 of the Constitution, rules with respect to the practice and procedure of the former High Court are applicable to the present court, and although no strictly accurate, it is convenient to refer to the rules which we have to consider as made under the letter's patent. On 11/10/1950 an application was made for a certified copy of the judgment and decree. The copy of the judgment was ready on 22/1/1951 and delivery was taken on the following day. The copy of the decree was not, however, ready until the 5th March and delivery was taken on the 7th March. In the meantime, on 21/2/1951, the appeal was presented but was not accompanied by a copy of the judgment. Paras 2 and 3 of Rule 7 of Chapter 3 of the Rules of Court as then in force.